Order 39 of Civil Procedure Code deals with grant of temporary injunctions. Not just temporary injunctions, it also deals with grant of ex parte temporary injunctions. The granting of temporary injunctions is a very crucial stage in any case. It casts a very higher responsibility on the Hon'ble Courts. Before taking a decision to grant an injunction, the court needs to exercise great amounts of caution. One is, prima facie, is there a right of the applicant? What are the facts that are concerned? If temporary injunction is not granted, what is the amount of suffering that the applicant has to undergo? What is the irreparable loss? Or is it a repairable loss that can be compensated in any other form? So these are all the concerns that needs to be addressed by the Hon'ble Courts. Not just the concerns of the applicant, equally the concerns of the defendant also need to be looked into. In case if the temporary injunction is granted in favor of the applicant, and if the case is adjudged, if the case is decided in favor of the defendant at the later part of the case, when the case is decided, if the defendant wins the case, if the case is decided in favor of the defendant, and if there is a grant of injunction, and because of such grant of temporary injunction, if the defendant has undergone irreparable loss because of the act of the court, who will be held responsible for the losses that are irreparable and suffered by the defendant? Therefore, it is just not the applicant's rights, it is also the rights of the defendants. Both needs to be crucially, critically examined before grant of temporary injunction by the Hon'ble Courts. Courts should also take into consideration that in case if temporary injunction is granted, and if the business or if the property in question are subjected to temporary injunction, because of which the defendant has suffered a loss, and in case if the case is adjudged in favor of the defendant at later part of the trial, then the compensation thus suffered by the defendant must be paid by the applicant to the defendant. This is the point that has to be considered. Therefore, before granting the stay, the court has to take the surety, the guarantee from the applicant that in case if such an injunction is granted, and if it is going against the defendant's rights, in such situations, the making good of the loss of the defendant because of a grant of a temporary injunction has to be borne by the applicant, and the Hon'ble Court in question will have to take up the responsibility of such incidences. Therefore, according to me, the stage of granting temporary injunctions is very crucial, especially when granting of a temporary injunction, ex parte injunctions are given. That is much more dangerous. So it must be exercised with great caution only in rarest of the rare cases where the fundamental rights of the applicant are attacked, they are disturbed. Until unless the applicant's basic human rights, basic fundamental rights, basic constitutional rights are violated, until then there is no scope for granting ex parte temporary injunction. both parties must be heard. Though it is the discretionary power of the court and nobody can question the courts as such. But all said and done, the law also provides to look into the factors which determine the case facts at a future stage. So the court has to consider in case, if the case is decided in favor of the defendant in future course of time, based on the facts, based on the law, then because of the act of the court of granting a temporary injunction, if the defendant has suffered a great loss, irreparable loss, which cannot be compensated by monetary value alone, in such situations, the law is tilted. Therefore, the courts will generally exercise great caution while awarding a temporary injunction, especially a temporary injunction, ex parte temporary injunction is